Good day, everybody. Today we are another edition of Garris Horn's podcast Insights. Today we actually have a very interesting and actually significant topic to report on. I want to introduce who we have actually to speak to. It's not going to be me. We get smarter guys than me. So I want to introduce who's joining us. First of all, we have Dave Ross, a partner here, a litigation partner here at Garris Horn. He focuses on business and employment litigation and assists clients with government and investigation enforcement actions. So thank you, Dave, for coming on. We also have Benjamin Takis.
Takis.
Got that right. Okay, thank you. I'll make sure you get that right. Is the founding attorney of Takis Nonprofit PLC, a Washington, D.C. law firm practicing in the fields of tax, corporate governance, employment law, and business transactions for nonprofit organizations. Ben is also the co-founder of Sustainability Education for Profits, and that's just
for nonprofits.
Nonprofits. Sorry, my bad. For nonprofits, the website is SE4, the number 4, so SE4nonprofits.com, an education website for nonprofit organizations. So thank you, gentlemen, for joining us today on our Garris Horn Insights podcast. Like I said, I think you have a key thing to report on in particular case. So if you want to hit the topic there, and we'll take it from there. So today, nonprofit corporate governance disputes under DC law, a case study. And to be clear, and you'll see it's obvious, these gentlemen were intimate and working on this themselves, so that nobody's going to know this better than them. So for our overview today, after over 6 years of litigation, Dave Ross and Ben Takis won a case-ending appellate court victory for the Open eBook Forum, also known as the International Digital Publishing Forum, or IDPF. The court's opinion in Overdrive versus Open eBook Forum is a rare published opinion on the DC Nonprofit Corporation Act and the first case addressing certain key nonprofit corporate governance disputes in DC. So what we're going to cover is a brief summary of key facts of the case and the background of law and procedural history. We will actually look at some key holdings and takeaways from the DC Court of Appeals opinion in Overdrive. And so with that, I think it's, look, you guys, looking forward to what you have to say. So, Ben, take it away.
Thank you, Ray. So just by way of background, I will start by saying this case involved a 501c6 nonprofit trade association in the digital publishing space, that is IDPF. That was my client. And after I brought Dave in, our joint client, and that IDPF sought to execute a kind of merger type transaction with a larger nonprofit called the World Wide Web Consortium, or W3C. And I will also just say my involvement, as you mentioned in my bio, I do business transactions and corporate governance for nonprofit organizations. I'm really a transactional attorney. So I was involved in the negotiation and drafting of this transaction, of the deal. When I saw that it was about to, elevate into a real dispute, that is when I brought Dave and got Dave involved. And what is great about Dave is I know that he can quickly absorb the law, even if it's an area that he doesn't work in every day. This is what I do every day, but I do not do any litigation. So I knew Dave could come in and, in the pre-litigation phase, make sure that we were ready. And then, of course, lead the litigation and guide that strategy. So that's how we both came to be involved. Now, in this case, as we'll talk about, this was not technically a merger. You tend not to see a lot of, the strict statutory mergers, but as is common, this was a transfer of assets, most notably some specific intellectual property assets. And we paired that with something called a membership exchange under the DC Nonprofit Corporation Act. Our client had some members who had voting rights, and they were going to have some rights in the new organization. So that's basically how we structured it. Again, to that point, our client, IDPF, was a membership organization under the DC Nonprofit Corporation Act. And for anybody who's not familiar with nonprofits, what that means is that IDPF had members with certain rights to elect directors, and vote in officer elections. The members also have rights to get access to certain documents and to vote to approve certain corporate actions. In the nonprofit space, it's kind of analogous to stockholders in a for-profit corporation. But since there are no owners of a nonprofit, instead you just get certain voting rights. In this case, the transaction was approved by IDPF's board of directors, and then there was a vote of IDPF's members, and it passed with over 80% approval. However, the plaintiff, Overdrive, sought to stop or delay the vote. They wanted to organize opposition to the transaction and ultimately block the transaction by suing in DC court. They also sued in a separate copyright lawsuit in federal court, but the DC case is what Dave and I were involved in. Now, prior to the lawsuit, this was brewing for a while. Overdrive did send some demands. They wanted to get extensive documentation and information, including but not limited to, and this is an important factor, email addresses of each member's primary representative. So with a nonprofit that has voting members, oftentimes the members are organizations or companies, and there's an individual who casts the vote on behalf of the organization. So that became an important issue in this case. What right do they have to get that specific information? We argued that these demands went way beyond the documents and information that Overdrive was entitled to get under DC law, and that our client, IDPF, had no obligation to provide the email addresses of the primary representatives. And importantly, our client's bylaws included a provision by which members could petition to hold a vote to rescind a board action. And in this case, the plaintiff didn't use that or even really attempt to use it. And that, as you'll see when I pass it over to Dave, is going to be an important factor in this case. And our argument, we kind of based our argument on this provision. Under a specific section of the DC code, we argued that because this provision was there and they could have used it, that this should prevent the court from granting Overdrive's request to invalidate the transaction. So real quick, before I pass it over to Dave, I'll give a little more background about how do nonprofit board actions get challenged in a nonprofit setting, and specifically under DC law. First of all, if there are any internal mechanisms that are created by the articles of incorporation or bylaws, anything that, a means of addressing a dispute, bringing a dispute to the board's attention, resolving it that way, that is of course available. And make a mental note of this, because again, I teased it in the earlier slide, but this is going to be an important factor here. A member of a nonprofit corporation could bring a suit directly if they have some kind of direct injury. Some contractual right, if they feel they got kicked out of membership of the organization unfairly, something individual, a member can sue that way. There's also the possibility of a derivative suit, which has lots of steps and hurdles attached to it. But a derivative suit, as anybody familiar with corporate law generally will know, that is when somebody sues on behalf of the corporation, on behalf of the organization, to redress an injury that is alleged to happen to the organization itself, not to the member. In DC and some other jurisdictions, there are provisions to petition the court to enforce certain member rights. Members, as I said, have the right to inspect certain corporate records. They have the right to have member meetings, and you can petition to have the court enforce those rights. And importantly for this case, there is a provision that lets a member, a director, other people inside the organization with standing to petition for court review of a contested corporate action. And Dave, as I pass to you, this is the one that's important here, because this is the basis of Overdrive's lawsuit in our case. So I'm going to stop the share here and hand it over to Dave, and Dave, you can put up your slides.
Okay, so this war began with a battle in 2016. DC Superior Court. In October 2016, Overdrive filed a petition pursuant to statute and moved for temporary restraining order and preliminary injunction, halting what then was an imminent member vote on the transaction. That is the vote to which Ben referred before. So Overdrive accused the board of refusing to provide the members with sufficient information, with rushing the vote and otherwise running an unfair process. So November to December 2016, the court denied the motion for temporary restraining order, stopping the vote. Just for the uninitiated here, difference between a temporary restraining order and a preliminary injunction. The idea is that things are so imminent that we can't even wait for the preliminary injunction hearing. We need to have an abbreviated hearing and get this stuff dealt with immediately at the TRO stage. So the court denied the motion for TRO basically because the vote itself was not going to lead to what we call irreparable harm. That vote itself was not going to directly lead to this membership exchange and the transfer of assets. So because the TRO was denied, the vote went forward, and as Ben mentioned, the vote succeeded. There was an over 80% approval of that transaction. So Overdrive amended the motion for preliminary injunction that still had not yet been decided to seek just to halt the ultimate transaction. We engaged in an evidentiary hearing, and at the very end, we successfully moved to dismiss the case for lack of subject matter jurisdiction. So we did so with a 4-step winning argument, and there is a reason that winning is in quotes, because winning does not mean meritorious here. Winning simply means successful. We thought we were right. The court thought we were right. Everybody thought we were right. So step 1 of this 4-step argument, a petition had been brought pursuant to DC Code Section 29-401.22a, what I mercifully will refer to from here on out as subsection A. This is the statute to which Ben was earlier referring. So that section is the one that empowers a nonprofit corporation's members, among others, to petition the Superior Court to hear and determine the validity of the corporate action. So we say, okay, petition had been brought, but you have to look at DC Code Section 29-401.22c, which we will call subsection C, because that section reads as follows. Subsection A of this section shall not apply if a nonprofit corporation has provided in its articles of incorporation or bylaws for a means of resolving a challenge to a corporate action, ... I'll get to the other part of the ... in just a second, but this bolded section is what we were relying upon. And this is what Ben was teasing earlier on when he said, keep note of the fact that articles and bylaws are places in which you could provide for means of challenging. So that was what we relied on. Now, the second part of this sentence, but the Superior Court may enforce the articles or bylaws if appropriate, that is important for later. So this is our second teaser. So step 1, this was a subsection A petition. Step 2, but look at subsection C. Step 3, the IDPF bylaws did in fact create a means of resolving a challenge to a corporate action. Pursuant to the bylaws, a board action, quote, may be rescinded by a simple majority of a quorum of members. Now, the way to get a vote on that is for 14 primary representatives, 14 in this case, to petition to have such a vote. Specifically, the bylaws say a number of primary representatives equal to the number of board members. In this particular case, there were 14 board members, and thus 14 signatures were required. Now, there were, I believe, well over 100 members, so this is a small proportion. And then step 4, since the bylaws provided for a means of resolving challenges to corporate actions, thus satisfying subsection C, the court lacked subject matter jurisdiction to hear a case brought against IDPF pursuant to subsection A. We won, but that win was short-lived. And I should say, again, we thought we were right. The court thought we were right. Opposing counsel, judging by the arguments they made in their appellate briefs and the arguments they made in court, also thought we were right. And so did the very smart attorneys who mooted me in preparation for oral argument. Turns out we were all wrong. Because, according to the DC Superior Court, the DC Court of Appeals, which is the high court in DC, this statute is not a jurisdiction stripping statute, because when it comes to DC, only Congress can define the jurisdiction of the courts. And subsection A of this DC statute creates a cause of action that subsection C merely circumscribes. So although partial abolition of the cause of action affects the cases adjudicated by the court, it doesn't amount to a stripping of the court's jurisdiction, because if it did, it would end up being a violation of the Home Rule Act. So the case was reversed and remanded. 2020, back in Superior Court, we win again. See, our new strategy there, of which Ben was the architect, was to take discovery in the case and make a non-jurisdictional, very fact-specific new argument pursuant to subsection C. So our argument is this: well, yeah, sure, the court has jurisdiction and we're not challenging that, but its power to adjudicate the merits of the subsection A claim is, to use the Court of Appeals term, circumscribed by the existence of an internal process pursuant to subsection C. And the court's power in exercising its jurisdiction under subsection A is, getting back to something I teased before, limited to ensuring compliance with the articles and bylaws. We succeeded at summary judgment. Before it was a dismissal on subject matter jurisdictional grounds. This time it is a victory at summary judgment. Overdrive argued that the board's refusal to provide email addresses of primary representatives foiled its ability to obtain the 14 signatures, thereby rendering the remedy illusory. But we argued and the court agreed. IDPF had offered to provide the addresses if Overdrive agreed not to sue. And frankly, if this had been provided, there would have been no need to sue because there would have been use of the mechanism. And moreover, Overdrive CEO admitted during his deposition that he had devoted minimal time to trying to learn the identities of primary representatives through other means. Now, Overdrive also argued that the transaction itself violated the Articles of Incorporation, trying to enforce the Articles of Incorporation, because the articles had a supposed directive, I say supposed for a reason, supposed directive permitting IDPF to transfer assets only to, quote, organizations which are substantially similar, unquote, to IDPF. So W3C, it argued, was devoted generally to the World Wide Web, including HTML, and therefore did not qualify. It was not a substantially similar organization. We responded to that by noting that Overdrive had misquoted that article from the Articles of Incorporation, because that article referred not to, quote, substantially similar organizations, unquote, but to, quote, organizations which engage in activities substantially similar to those of IDPF. And there is a distinction. W3C, while not a substantially similar organization, engaged in digital publishing, along with lots of other things. So this is how I address this at the Court of Appeals, to which I will address in a second. But I drew an analogy here. Toys R Us, the dear departed Toys R Us, and Walmart were not substantially similar organizations, because Toys R Us was a toy store. Walmart was and is a mega store, but it did engage in substantially similar activities. They both sold toys. So there was a toy department. So that was an activity that was substantially similar to what Toys R Us was doing throughout its store. Just so happened you could also buy a lawnmower from Walmart or other things, but they did engage in substantially similar activities. And thus, that would have been enough if, say, Toys R Us were transferring its assets. And in our case, we have a much larger organization that does lots of different things. That organization that does lots of different things happens to have its own toy section, digital publishing, like what IDPF did. And therefore, not a substantially similar organization, but engaged in activities substantially similar. So we won at the Superior Court level. Same arguments in large part made at the appellate court level. And the Court of Appeals rejected Overdrive's argument that IDPF was once again trying to strip the DC courts of jurisdiction. Court of Appeals distinguished, as did we, between a jurisdiction stripping statute and a statute that simply circumscribes the power to address the merits of a cause of action brought before it. And it generally adopted the Superior Court's reasoning. Court of Appeals also noted that, quote, courts ordinarily will not interfere with the management and internal affairs of a voluntary association.
Thank you, Dave. And before I talk about key takeaways, I do want to emphasize, you presented that all in a nice little package, but it's important to keep in mind with litigation, as you know, this is new for me, not so much for you. This all happened over a bunch of years. We said at the beginning, this was kind of a 6-year process. You saw just the difference between the Superior Court opinion in 2020. It was 2023 until we got that DC Court of Appeals opinion. So that was, you know, that it was interesting to see all this play out. You know, it didn't happen as neatly, you know, as it might have seemed from your slides, because it took a lot of time. And I
Yeah,
will
and
also add, and I'll let you comment, Dave. The notable thing about this case, the plaintiff was really trying to throw the kitchen sink at us. And I think the real challenge was to control the narrative and keep it within the playing field that, you know, we thought was right and that was to our client's advantage, and try to keep the court from getting distracted by plaintiff's arguments. So I think that is what I'm really proud of. The work we did was to be able to keep it to this narrative, you know, that we're presenting now, and not get distracted by, they were throwing conflicts of interest arguments that didn't really have much merit, and the court ended up agreeing. They were throwing all kinds of things. Dave, did you?
Yeah, and I was about to go along the same path. These are the key issues. These are the ones that we discussed today, are the issues that really are going to maybe outlive our involvement. There were certain arguments made, there were certain just issues addressed that we are not providing today as part of our presentation.
Sure, yeah. So key takeaways, you know, beyond our clients, what are the important things that everybody can distill from this case? I think number one, this is an important new development in nonprofit corporate governance law in DC. Corporate actions will not be invalidated under the DC Nonprofit Corporation Act if the organization's articles of incorporation or bylaws provide non-illusory means of resolving a challenge to a corporate action. And the key there, non-illusory, that was a big part of the argument that we dealt with. And the court ended up agreeing that we had such a means and that was enough. And there would be no further court review if you satisfied that standard. I think, you know, if you are a member or you represent a member of a nonprofit organization with voting rights in DC, and there is such a provision, you would be well advised to view that as sort of an exhaustion of internal remedies requirement. Make sure you're aware and you're using what's in the governing documents first before you go to court. I think that's a key lesson from this case. Additionally, that's not going to save, you know, if you're an organization or a board of directors, this statute is not going to save you from review in all cases, especially if the action itself is not consistent with the articles, the bylaws, if there's some kind of voting irregularity, if there are conflicts of interest that are not properly managed. So all those things need to be taken care of. You need to, as a nonprofit, keep your house in order. But if you do, and you do have a means of resolving a challenge to a corporate action, there's a good amount of protection there. I would also say, if you're a DC nonprofit organization, particularly a member organization, think about revising your bylaws to provide a means of resolving a challenge to a corporate action. And basically, this is, you know, in our case, there was a provision that allowed members to petition, get a group of them together, 14 in this case, hold another member vote to rescind a board action. That was enough in this case. If you represent a nonprofit organization, or if you're on a board, think about what that might look like in your organization's case. Some kind of alternative mechanism that a member with a different opinion, or a board member, a director or an officer with a differing opinion can use before going to court. Another key takeaway, there was controversy over what does it mean to obtain the names and addresses of other members, because that's one of the key rights that a member in a nonprofit has. And the court held that this statutory right probably they weren't crystal clear, but probably does not extend to email addresses, or even the identity of the individuals who cast the votes on behalf of the members if it's an organization or company. So what you get in DC is names and addresses of the members, not necessarily a whole lot more than that. And lastly, I will just note, we did make an argument about the business judgment rule, which is very typical in for-profit corporation cases, where there's a high degree of deference, if certain minimal standards are satisfied. We tried to argue that that applies in this case in DC to nonprofit organizations. I think that is still left unclear because the court didn't address that argument. So there's a little bit of ambiguity. That's to be decided in another case to know for sure whether there is a business judgment rule that applies to DC nonprofit corporations. However, the court did affirm its general principle that they're ordinarily not going to interfere with the management and internal affairs of what they call voluntary associations, and that applies to nonprofits of various types. So I think that was a good principle. And on the whole, the courts showed in DC that they're fairly deferential to boards of directors and nonprofits with regard to dissenting members. We don't have a business judgment rule, but on the whole, we have something that looks a lot like it. So with that, I will take the slides down. And Dave, any final thoughts? Ray, do you have any questions?
Well, let me first go that. First of all, I'm sure the industry applauds what you guys have accomplished. Is by no means insignificant, and I can tell that from clearly what you have, and for 6 years of it, and the tenacity that it takes, of course. So I think that's important. From what I've seen, the key takeaways as well is you have provided the industry an opportunity to relook at things, or as it progressed going forward, how to tighten up on some of the. If you want to build something, do it. Pay more attention, be more thoughtful on certain key points. As I always say, as an attorney, when it comes to business, people don't really need a lawyer until you need one. So, so they like to simplify things, and we'll just put documents together. It's fine. And then suddenly it's like, well, I thought you meant this. I thought you meant that. So I think it's not by any means insignificant what you accomplished by doing that. Again, any time we can better understand how the law is supposed to be applied, I think it's great. And that goes back to both of you. But yeah, in fact, both you and Dave, what are we got your key takeaways, but again, your thoughts. I think it was a key point. You kept the narrative tight. I think that was significant because you have to make sure it's tight so you don't get distracted. And I think that was very key. What else do you want to mention? And now that you can drop your shoulders, breathe, and relax a little bit, and say we got this done. What are your thoughts on this?
Ben is a very good nonprofit attorney. Actually, I'm underselling him. He is an excellent nonprofit attorney. He was the brains behind this operation. I was his muse.
Yeah.
And he did a masterful job here. This was a good client who I was happy to get a good result for. And I'll say this, I believe everybody on both sides was acting in what they believed was the organization's best interests. Both sides were very sincere about this, and both sides, even though we did have to fight a kitchen sink type or a kitchen sink's worth of arguments, I do think that we had worthy and honorable adversaries. We really did.
Yeah, and Dave, I thank you for the compliment. I live with the DC code every day in my practice. I don't always see my work challenged. In fact, this is the first time in my career where I've had a major transaction go to this level. But my role, I tried to keep things clean so that, if and when they went to court, that you didn't have a giant mess to deal with. So I tried to do that. And then knowing the DC code and knowing some of these concepts, I tried to be of assistance. But, transactional wisdom is one thing, but expertise in guiding litigation, which, you're dealing with opposing counsel, that is something I would be totally out of my element. I would, I'm not a litigator, would never even try. And you did a great job on that. And that to me, I look at that and it seems very challenging. I don't know how you keep all these rules of procedure in your head and use it to the client's advantage as well.
Well, thank you.
Well, thank you, gentlemen. Like I said, I personally am impressed by it. I'm sure those who are watching it as well. By no means this is insignificant. I think it's very significant what you've accomplished. Kudos to both of you and the teams that helped you and the lawyers around you that helped you. The assistants and everybody else who helped you, made you look good, right? So I think that's quite awesome. Look, there's a good chance that people want to reach out to you. What's your contact information, maybe email address, or how can people get a hold of you?
Ben?
Yeah, well, people can find me just at my law firm website, takisnonprofitlaw.com. T as in Tom, AKIS, nonprofitlaw.com. You can contact me through contact form on that page. And I have more educational stuff, as you mentioned up top, at my education website, se4nonprofits.com. Everything there is free. Me and a CPA just put out information, to help nonprofits understand these rules and understand how to be more sustainable. So you could reach me there as well.
Very good. Thank you.
You can reach me at dross, that's my first initial, last name, at garrishorn.com. Anybody watching this probably knows how to spell Garris and Horn, but I will anyway, GARRISHORN.com. My direct phone line is 301-651-1694. And one can find me, of course, on the Garris Horn website.
Well, again, thank you, gentlemen, for your time and your presentation. We greatly appreciate it. And for those who are watching this, like and subscribe and, watch other things that we can do as well. But again, thank you so much for your time. And frankly, congratulations on your success.
Thanks, Ray.
Thank you very much.
Thanks, Ray.